Everybody ready?
Almost 1 second.
Okay.
Could you hold that white piece of paper up again one more time? Thank you.
Does everybody have a copy of the charges? You're welcome.
Matt, I've got one. Thank you.
I'm so glad I made extras.
Could you, I'm sorry. Could you have one more with this?
You want another one?
Can I just say something for me, please?
Check, check, check.
Okay, very good.
I wish you all safe travels on the way home. And a Happy New Year. Thank you.
Good?
Ready to go? Okay.
One more wait.
Oh,
Give me one more white belt.
ready? So I know you understand that we're not allowed to, our office is limited in what we can say. We're not going to be able to talk about the evidence in the case. And while he'd like to answer all your questions, I know the district attorney is going to abide by all the rules. So keep that in mind when you have questions to ask. Speaking today will be 4th Judicial District Attorney Dan May, and also Senior Deputy District Attorney Jennifer Veman, who is the lead prosecutor in the case. There was another prosecutor you saw in court today. That's Deputy District Attorney Beth Reed, who is still in court. She has docket today, so she was not able to join us. And with that, here's 4th Judicial District Attorney Dan May.
Good morning. This morning, the District Attorney's Office filed 5 felony counts against Mr. Frazee, 2 counts of first-degree murder. Now, obviously, there was only 1 murder in this case. Under Colorado law, we file separate counts on the different theories of first-degree murder. We filed under 2 theories. One is deliberation murder, and the other is felony murder. Felony murder in this case, as set out in the charge, is that when you rob somebody and they die during the robbery, that is also first-degree murder. So we have filed under both theories in this case. We also have 3 separate counts of solicitation, and those are 3 separate counts. They are not different theories in this case. So it's a total of 5 counts, 2 counts of first-degree murder, 3 counts of solicitation that were filed against Mr. Frazee in this case. With that, I'll turn it over to Jen Veman.
Good morning. I want to talk a little bit about what our next court dates are. As you probably all heard, on Friday we're going to be addressing 2 particular motions. We're going to be addressing a motion for consumptive testing. The basis of that motion is that anytime there's a very small amount of evidence, the lab will tell us that they cannot complete that testing without it being consumptive. We then notify defense, and then defense has an opportunity to send an expert, send someone along to observe that testing. So we're going to be discussing that on Friday. Also on Friday, what we're going to be discussing is the sealing of the probable cause affidavit for and in regard to Mr. Frazee himself having access to that probable cause affidavit. The defense will have a copy of that. At some point, we will be addressing unsealing the motions in this case. The other court date that you all heard is going to be January 29th. On January 29th, that is the preliminary hearing. At that time, we will be presenting evidence to the court and asking the court to bind over all of the charges that we have charged Mr. Frazee with. There will be testimony and there will be evidence presented at that court date on January 29th.
Does the fact that you're having to still put these two theories together mean that he has not given an interview to authorities?
I can't really speak as to what Mr. Frazee has done. I think you can glean that from previous statements that have been provided by his defense counsel. In terms of what evidence we have or what we will present, I can't speak to that.
Why keep the arrest affidavits sealed? I mean, he's got a constitutional right to know what he's accused of.
The reason why the affidavits are sealed at this point is because this is an ongoing criminal investigation. There are multiple leads that law enforcement needs to follow up on, and it's extensive. So we're asking that that be sealed at this point until those leads can be followed up on.
How long can you reasonably hold him without
Sorry.
presenting any evidence?
You could look this way.
Yes.
How long can you reasonably hold him in jail without presenting any evidence against him?
Well, the way the rules work is that he's going to be held in custody until, he's held without bond at this point, and he's going to be held without bond until we present that evidence on January 29th. And it's at that hearing that the judge will also be making the determination as to whether or not he should be not only bound over for the charges that we have filed against him, but also whether he should continue to be held without bond. Mr. Frazee will be hearing that evidence on January 29th.
Is there a limitation, though, on how long you can hold somebody? Presumably this could go on for months, though, right?
I'm sorry, could you repeat
If
that?
the investigation continues to stretch on, is there a limitation on how long you can hold someone in jail without presenting the evidence?
Go ahead.
Pursuant to the Constitution and Colorado law, the judge has reviewed the arrest warrant in this case. A neutral magistrate has looked at that, and she has determined that there is probable cause for first-degree murder and solicitation of first-degree murder, which is what was presented in the arrest warrant. She has also determined a no bond hold at this time, and so it has been reviewed by the courts. On the 29th at the preliminary hearing, that's an open hearing to the public. And again, we present evidence at that time on the 5 specific charges that we have now filed, at which time the judge will determine if there's probable cause to bind over those charges for trial. At that hearing, you heard the term today also, proof evident, presumption great. What that is at that hearing, the judge will determine if we have if the proof is very evident in this case, and if the presumption is great that he will be convicted, then she will continue to hold him on a no bond. If the judge at that time rules it is not proof evident or presumption great, then she will set a bond at that time. So that's how the process is, but it has been reviewed by a neutral magistrate at this time. In terms of the sealing, I indicated in the previous press conference, I anticipated that law enforcement would, from that date, would want the arrest warrant and search warrant sealed for about 30 days. I'm not changing my opinion in terms of the sealing of that from the previous court date. We anticipate the defense attorneys will get the arrest warrant today. They asked for that, and they'll have that today. I imagine they will get more warrants very soon, and we are really following the guidelines of what the investigators want, and I'm anticipating it'll be some weeks before those warrants are unsealed. Otherwise, at the preliminary hearing, much of the same information will be put on at the preliminary hearing on January 29th.
Mr. Ray, without getting into too much detail.
How likely is a second arrest, and can you give any sense as to what a motive may be in the case?
Again, all facts in this case are under seal, so I cannot talk to you about any potential motives in this case. We've indicated Chief Miles DeYoung from Woodland Park Police Department in the previous press conference said that there potentially could be other people arrested in this case. Again, I'm not going to comment beyond his comments.
Is the
Those
reason
three-
that you've got 3 solicitation charges, does that mean that you believe you tried to solicit 3 different people to kill?
Again, the charges themselves do not specify who may have been solicited in this case. All I can comment on is that what is in the public record, and what's in the public record are the charges. They're pretty self-evident in terms of there are 3 counts of solicitation. They are 3 separate counts of solicitation. It is not different theories.
Can you specify how unsealing the warrant would interfere with the investigation?
Sure, the police have a lot of leads. You know, this is a task force. They're dealing with a lot of law enforcement agencies. Quite frankly, this case is coming down during the holidays, which also makes it difficult to follow up on leads. Just finding witnesses sometimes can be difficult during the holidays. They've got a lot of investigative leads, a number of interviews they want to do, a number of items they have to collect, and quite frankly, releasing all that information to the public could hurt their ability to do that investigation. I don't want to get too specific, but in general, there are interviews that they may need to do with people that might not want to interview if they're in the national press first, with their names and faces and everything else. Quite frankly, I know that you or other members of the public might try to hunt down some of their leads that would be in the affidavits that they need to do. They need to do their law enforcement first. And in this age of technology, a lot of pieces of evidence can carry very fine items of evidence on them, such as DNA in small amounts, and if people are interfering with those items before the police can get there, it can make it so we can't use those items. Those are real generic reasons for it, but our position from the DA's office on the unsealing of the warrants is strictly coming from the investigators in terms of what they're asking us for. And I can tell you they have a number of leads that's been expressed in court a couple times now that they need to follow up. Again, the other thing, Woodland Park's a small agency. They are getting a lot of help, but, manpower resources are limited when you're in a small jurisdiction. The judge today even referred to that just for the courts, that it's a small jurisdiction. And so it takes time to be able to go through all those leads. So I think at this point, what they're asking our office for 30 days from the last press conference we had, I believe is reasonable under the circumstances, and I know they're working very diligently.
So is the solicitation charge, is it 3 separate people? Or can you just explain what that means, that there's 3 charges on here?
Again, all I can tell you is what's on the public record at this stage. You heard the judge today entered some orders on what we're allowed to refer to the press. On the public record are the 3 charges. They are 3 separate counts. It does not name anybody at this time in those counts, so I cannot comment on who it is that's being solicited, but there are 3 separate counts of solicitation in the charges.
And it has a time frame. Does this mean it happened over a period of time, or you're not sure exactly when it happened? It says September 1st to November 1st?
We do have to allege in any, and this is going to be more of a generic answer in terms of charging, not necessarily specific to this particular case. Generally, we have to name the dates when certain things happen. Generally, you'll see that we do broad dates in a number of counts that we do to make sure that it's all inclusive. We do have to name dates that are within the statute of limitations. I mean, that's how broad we could make it, but that doesn't really give the defense sort of fair notice. So we have given them some broad dates on those 3 particular charges. They are not as specific, but it gives the general range of when it occurred.
The defense team seems to have some serious concerns about, with it being a small community, being able to get a fair trial here. Are there concerns about this whole process continuing to happen in Teller County on your end as well?
Your question's putting a little bit of the cart before the horse. We'll see going into the future. I have seen in some cases that you can ask for changes of venue. I don't know that we're at that point. I think currently one of the reasons everything's under seal is to allow for due process to occur, and we're always mindful of that. All parties in the courtroom are very mindful of their duties and obligations and want to make sure the defendant gets a fair trial. We're all concerned about that. I will say that it does bring up a point that, for instance, on the sealing, I've mentioned how long the prosecution will be asking for those warrants and affidavits to be sealed. It could be once we aren't the final say on that anymore. The judge will be the final say. And it could be the judge may or may not release it. It could be the defense may or may not want them released. You'll see that in the future. Quite frankly, the press, I have had cases where the press has filed motions to ask to unseal warrants at different stages if they feel that it's being withheld from them and they have a right to that. I can tell you that happened in the Deere case that we had some hearings on that. So we'll see where that goes, because I know you represent the public. You're the eyes and ears of the public to be able to know what's going on in the courtroom. But we'll see. But that's where everybody's concerned about the due process rights of all parties in this case.
I know you have some time to decide this, but what is your current thinking on whether or not this is a death penalty case?
Under Colorado law, you've heard that we have the preliminary hearing on January 29th. After that date, the defendant is required to enter a plea. They can either plead guilty, not guilty by reason of insanity. Certainly you've seen across the country, generally it's a not guilty plea. From the time they enter their plea, under Colorado law, we have 9 weeks to decide whether we will seek the death penalty. And if we do, we actually file a formal notice in court. My office follows that particular law, so we make no decisions on that prior to that date. So once the preliminary hearing occurs, the defendant could enter a plea that day or could ask for a continuance to enter a plea at a later date. Once they do enter a plea, we have 9 weeks to make that decision. At that time, we'll be talking with law enforcement, family members, others in the public, the defense, in terms of making a decision. But it is not a decision that's made under Colorado law now. That'll be weeks from now.
One of the questions that we had, from the public is the search that's ongoing. I know there was evidence that was found in Idaho. What can you speak to? Because I think people are wondering, if police are still searching and possibly where.
Well, that's why everything's under seal that we're talking about. Yes, the police are still searching, but I'm not going to tell you where.
Are you finished in Gooding, Idaho, or are you still investigating in Idaho? Is there
Again,
investigation going there?
all facts are under seal, and I'm not going to indicate where any investigations are going on or where any searches are being
Sir,
done.
can you just speak in general terms about the difficulty of the case, multiple states involved, multiple leads, as you guys have said, Kelsey has not been found. Can you just talk, just general, not the evidence, but just general terms about the difficulty of this case?
This is a very tragic case. Everybody knows that. She's been missing since November 22nd. The family's come out here, and I think that's been well documented in the news, trying to find Kelsey, trying to find their daughter. The police were notified about 10 days into her being missing and have been very diligently working. They've actually assembled quite an impressive task force from the Colorado Bureau of Investigation, which you've heard is CBI, Federal Bureau of Investigation, which is FBI. Obviously, you've heard that they've gone across state lines to other law enforcement agencies. Our office has been very involved. The Sheriff's Office has been very involved. You've been seeing in the media, there have been some searches that you have noted in your press releases in terms of on properties, but it has been very extensive. Obviously, everybody it was hopeful how this would end. Unfortunately, we are filing 2 counts of first-degree murder today and solicitation for first-degree murder because the evidence suggests at this point those charges are appropriate, and that's what we have filed.
Is Patrick Frazee the only person that was initially looked at by investigators in this case?
Again, I'm not, his question was Patrick Frazee the only person looked at, and I'm not going to comment on any of the investigation in this case. It's all under seal.
I think we've sort of veered off on things that our office is just simply not allowed to talk about, but we thank you for coming. I hope you drive carefully.
Anything else?
Mr. Bates, could you give, we had a little audio comment at the very beginning. Could you also state once again all the charges that were filed today?
Certainly. Today, the District Attorney's Office filed 2 counts of first-degree murder and 3 counts of solicitation of first-degree murder against Patrick Frazee.
And could we have the spelling of your co-counsel's last name?
Sure. Jennifer?
Yes, it's Vieman, it's V as in Victor, IEHMAN.
First, there's a custody hearing, are you guys going to be present at that?
We actually have no involvement in the custody hearing,
You're not going to be present at all?
no.
We may be.
Well,
If you remember last time the court, I guess each date will be up to the judge. I did get to sit through the custody hearing previously. We are not parties to that action. It's not an area that we deal with. The county attorney here for Teller County is the one who deals with that. When they made their motion, the judge indicated under the statute that she did have the power in certain circumstances to remove the general public for the hearing, but there were certain parties she could not. So at the custody hearing, she indicated in the public record there orders on who could be there or not. The district attorney's office was allowed to remain there. Whether we'll be at the next one, we'll see, but we do have a right to be there.
Do you have any information on how Sheila Frazee is intervening, or what her points are that
Not-
she's making?
Right. Again, if you want questions answered about the custody, it's not our area of the law. It's not one that we're a party of. The county attorney for Teller County is the one who represents the county in that case. So you probably ought to inquire from them and see what they're able to talk about or not. The judge did enter some pretty strict sealing orders, if you will, in the custody. But the county attorney is the one to better address that. They understand the procedures and they're a party to the action. We are not.
And we'll see it all next year.
Thank you very much.
everybody in the car, and everything.
Yank real hard, they'll all come off.